Okay, let's set on some house rules. Mr. Ombija, you are leading the team?
Yes, I'm leading the team.
So who is going to make the application?
I'll make the application.
How much time do you need?
Your Lordship, we have three-pronged attack on this application.
How much time do you need? We are settling the rules first.
About 45 minutes.
45 minutes. Mr. Ondari, who is leading?
I will be leading the team.
How much time will you need?
We will take 40 minutes.
40 minutes. Okay. Mr. Kaluma, will you want to address the court at all?
Yes, at this stage, we would wish to address the court. And if the court were to permit, lady, we will be requesting that Mr. Ayora makes submissions on our behalf.
How much time?
10 minutes.
10 minutes. Any objection to that submission by Mr. Awara?
Yes, we have not been served with any document.
They don't need from the victim, like victim impact. 5 minutes.
Yes. Not a good thing. I will proceed with layer 2, which is that the Honorable Court will please release the applicant on bail or bond on such reasonable conditions of the court may determine. And number 3, that this Honorable Court will please to issue such orders as may be fair and just to secure the applicant's constitutional right to be released on bail or bond pending the conclusion of his trial. The application is precluded upon the affidavit of Zachary Obado, the accused person hearing. And on the following grounds: number 1, the offense of murder is bailable under Article 49, 1H of the Constitution of Kenya 2010. 2, the applicant has a qualified constitutional right to be released on bond or bail on reasonable conditions. Number 3, the applicant has a qualified constitutional right to be presumed innocent until the contrary is proved. And number 4, the applicant will avail himself to court as and when required to do so until the matter is concluded. Number 5, the applicant shall abide by any conditions that shall be set by this Honorable Court as a prerequisite to grant or bail or bond. Number 6, the applicant shall not interfere with witnesses in this matter and any investigation which should be carried. And number 7, the applicant has supported with the investigation so far. Now, we adopt the affidavit of Zachary Obado, which is in 19. It was sworn on 24th of September 2018. And we emphasize paragraph 7, paragraph 8, paragraph 10, 11, of the said affidavit. Your Ladyship, cognizant of the fact that Kenya is a constitutional democracy governed by the rule of law, we take the lead by invoking the provisions of Article 49, sub-Article 1H. And being aware that the Constitution of Kenya, aforesaid, does not provide for the procedure in such an application, we invoke the provisions of Section 123 of the Criminal Procedure Code. We reiterate that every accused person has equal protection and equality before the law. We are sensitive of the fact that the Constitution of Kenya at Article 165, sub-Article 1B, and Article 49, sub-Article 1H, together with the Criminal Procedure Code at Section 123, bestows upon you the jurisdiction to enforce the Bill of Rights. As crystallized in Chapter 4 of the Constitution of Kenya. In addition to the Bill of Rights as enshrined in the Constitution, we are also cognizant of the fact that there are international instruments which have been ratified by Kenya and therefore form the part of the laws of Kenya by dint of the provisions of Article 2, sub-Article 5 of the Constitution. That deals with unalienable rights of human beings, and are contained in Article 48, economic, of the rights of, and in interpreting the Bill of Rights, the court is enjoined to promote the values that underlie an open and democratic society. And Article 21 of the Constitution. It's the fundamental duty of the state and every organ thereof, including this body, to observe, respect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. And we urge your leadership to give effect to those constitutional provisions. which are so sacrosanct, cannot be wished away by the whim of the state. Having said that, I wish now to underscore the principles upon which this court and the High Court grounds bail. The fundamental principle for bail is to ensure the attendance of the accused person at his trial. So the question this court will ask itself is the accused person capable of attending his trial? Is he likely to evade justice? That this person has undertaken to abide by the conditions that this government granted and attend not only the hearings but also such meetings. Or any other order that is what might be fatal. But the grant of bail is not a matter of course. It is discretionary. We hereby invoke your discretion. To grant the applicant the bail. In granting bail, the court should take cognizance of the fact that the amount of bail should not be more than will probably secure the attendance of the applicant. And that amount should never be so large as to amount to denial of justice. I'm aware of the fact that each case must be treated having regard to its particular circumstances. The applicant has been tried, convicted and executed by the media. And we urge in considering this application to discount the innuendos, the rumors, the half-truths, the falsehoods that have been peddled by the media. send. If this,
But then what does Article 49 say? Article 49 is so clear that any accused person or suspect who is brought to court shall be entitled to bail. And compelling reasons must be given. So when you tell us that, when we are told, my lady, that they have a strong case and it's a capital offense, how is that a compelling reason? Paragraph 14 tries to take the chunk of that affidavit. And they tell us that the investigations are not yet complete. That they'll be proceeding towards Migori and to and fro. What are we doing in court today? Why did they bring the accused person in court today if they have not completed the investigations? Why did they rush to bring the accused person to court today if it's not pressure from the public? So when they tell you the investigations are not complete, how is that again the problem of the accused person? Because when they have brought him here, the presumption is that they have finished the investigations. So let us take that avenue, that they have completed the investigations. Anything else they are saying is just blanket to add to the meat of the application. They are being told in that same paragraph that the 3 abductors or hitmen are still at large. They have not told you how these hitmen are related to the accused person. How those three men being out there, who we don't have their names here today, or know who they are today, can be a compelling reason against the accused person. But then they try to mix it with a little bit of cheekiness, if I can say, my baby, and say that the accused person has a lot of influence in Migori by virtue of his position as a governor. Yes, he was elected by more than 350,000 people. Yes, he has influence, but that influence is of a political nature, not of a case like this, not on people who are witnesses in this case. They need to differentiate that his influence is based on politics and nothing of this kind. They need to show you further how his influence then is going to affect this case, and that his being inside shall cure it. Because influence is influence, inside or outside, but they must put some meat to it and show you how it is going to affect it. And being a person on the free influence is not a problem. And that is why, my lady, I must invite you to have a look at Richard Alden versus Republic. That is case number 48 of 2016. I will also invite you to look at Dwight Sagarai versus Republic. That was case number 61 of 2012. Rogers Nzioka versus Republic. Miscellaneous application number 13 to number 18 of 2018.
5 minutes to go. 5 minutes to go.
5. You have 5 minutes.
Yes.
And these ones you are quoting, have you
Yes, they're all there. Yes, they're all there.
The last
all those ones were
the last one was miscellaneous.
Miscellaneous application number 13 to number 18. There were various applications of 2018. In Richard Alden versus Republic, this matter, my lady, was before you. And all those sorts of allegations were brought in, whereby we were saying the accused person was a person of influence. But my lady, you dealt with that properly and indicated that that influence needed to be proved, and to what extent and how it was going to affect the case. It is the same with Dwight Sagarai, who was working for the Venezuelan embassy, and what was said in that case. Influence must be shown, and must show how it has affected this case, how it is going to affect, and whether that influence will be able to be used in any way to exercise to the witnesses. In the miscellaneous application that I have told you, Justice Omudi indicated quite clearly that in as much as the PS in that case and Richard Dubai in that case were influential people,
It is not enough to just see that they're influential. You must then be able to show how that affects. So are we going to use his position as a cause to crucify him? It is simple. The court can even warn him and tell him, please do not use your influence, do not interfere, do not do anything. He's a law-abiding citizen. And they say he might abscond. Yet when this matter started from 3rd of September in the investigation, he has not run away. They arrested him on the 21st of this month. He did not move away for almost 3 weeks. How then do they imagine he's going to abscond? And in all these authorities that we have quoted, the courts have said that you must put material before the court to show that he has attempted to abscond or was prepared to do so. In the same authorities, it has said quite clearly that in case you are saying there's interference, you must show the interference. Is it direct or indirect, and how it has been done by the accused person. In the miscellaneous application, the court has also said that mere allegations that a person will influence investigations or interfere with witnesses is not sufficient. Material must be placed before that court. So what material do you have here? You're being told that the family has been threatened in that same paragraph. But look at that paragraph again, Leon, and I will invite you to look at it. There is no OB number to show whether that has been reported, because when somebody is threatened, it is a crime. It has no date, it has no time. And this is an offense that is time specific. It cannot be looked at in any other way. We do not know even who the complainant is. So you're being told family. Who is family? Somebody specific must have been threatened and told specific words. If you do this or you do that, this will happen to you. That is what is a threat, not allegations. And you're being told in paragraph 18 that the intricate relationship between the accused person and the individual professions recorded by some suspects called Jefferson Otieno Gombe. Does the prosecution forget that there is a witness protection program? Do they forget that that act exists? If that witness is vulnerable, why haven't they put him in such a position? Are those family members witnesses in this case? And yet you're being told that he has recorded a confession. And we shall be saying under Article 50, sub-Article 4, this confession is not a genuine one. It was made falsely, it was doctored. So if they say they have a confession, we are countering and saying it does not hold any water. And we'll be able to show in this trial. As I finish, my lady, Article number 19, you're being told, paragraph number 19, that if you release the accused person on bail, it will compromise the safety and security of the co-accused in this matter. Who are the co-accused? Because in this charge sheet today, we have only one accused person. Who are the co-accused? Let them not just make allegations. We must see who the co-accused persons are. They are not in this charge today, and that affidavit only mentions the accused person. How is then that a compelling reason? And you're being told that it is bringing up a problem, generating some anger, outrage in the county. What we have seen are people who are coming out with placards to support the accused person. They are saying, free the governor. He's an insolent man, he's a humble man, let him go. And that is the position we are also saying. So when they come out and tell you that there is outrage, when and where, please show that to the court, so that the court cannot speculate, cannot imagine, must see the fact. My lady, just so that you're being also informed that the accused person is at risk. It's the last one, the point, my lady. Is at risk of being maybe attacked or being injured, or he'll be at risk. His life is at risk. That's what the word they're using when he's in the county and all that. Ngetich versus Republic, 123 of 2010 at Nakuru, Justice Ouko, as he was then, said that it cannot be heard from the mouth of the state that a person is only safe when he's in custody. What are the other arms of government doing? What what are he has his own security. Nobody has threatened him. They needed to show you that he has been threatened, or people have said if he comes, we will lynch him. That is missing. So when you look at these authorities totally, and when you look at Article 27 where we shall not discriminate against him because he's a governor, we start with equal footing, so that he is an ordinary citizen when we come before court. Today, he is not the honorable in this court. You are. For him, he is an accused person, and we start with equal footing like everybody else. So today, this affidavit does not give you compelling reasons. The contempt that he deserves, you will give it out.
I wanted to see a road there and I'm not seeing it. A path. We need it for air because already I can hear it too stuff. In fact, they should put them on one side so that we have air. What is happening? Yes. You said 40 minutes?
Yes. My lady, this is the order in which we prosecute our response. I'll deal with the grounds or compelling reasons for denying the accused person bond or bail. And my colleague, Mr. Muteti, will respond to the authorities filed by the applicant. This response, Your Honor, is supported by the affidavit sworn by Mr. Clement Mwangi, Inspector of Police, and authorities filed in court. We have provided a list of authorities which will be relying on. Before I start our substantive response, Your Honor, I wish to disabuse some of the misconceptions and falsehood fronted by the applicant on a number of constitutional and legal issues. One, that the presumption of innocence is being violated by our opposition to the release of the accused person on bond or bail. Nothing can be far from the truth. Of course, everybody knows and appreciates that any accused person is innocent until proven guilty. That has nothing to do with bond or bail. Fair trial is contained under Article 50 of the Constitution, and nowhere does it state that the grant of bail or refusal of the same is a violation of the right to fair trial or hearing. The presumption of innocence does not mean that one may commit an offense, a grade one at that, at will, and brag that he is innocent until proven guilty. Secondly, Your Honor, Article 49 does not state that the right to bond or bail is an absolute right. Of course, my learned friend appreciates that neither the Constitution nor the CPC provides what is compelling reason which may deny an accused person bond. This has been settled by a number of authorities from this court and outside jurisdiction. And we are going to demonstrate that fact. The third misconception, that the right to bail is an inalienable right. That is not true. My lady, inalienable rights are contained under Article 25, and there are only 4. These are the rights which cannot be limited in any way and by anyone. And this is the freedom from torture and cruel, inhuman or degrading treatment or punishment. 2, freedom from slavery or servitude. 3, the right to a fair trial. And 4, the right to order of habeas corpus. This is not an habeas corpus. There is no allegation that fair trial has been denied, and therefore it is a misinterpretation of what inalienable right is. And we are going to demonstrate that this right, Your Honor, may be limited, just like any other rights other than rights under Section Article 25. 4th, the defense has alleged that the accused person has been tried and convicted by the media. That may be so, my lady, but this court has not convicted him. And the court considers only what has been put on record and is never persuaded or swayed by outrageous or outlandish comments by people and idlers out there. Therefore, this is not an argument for grant of bail. Sixth, my learned friend Mr. Obado argues that this is a self-activating right and seeks to address that point by saying that exceptional circumstances may be found in a dictionary. With due respect, Your Honor, you can never find interpretation of law in English dictionaries or thesaurus. And that 7, by the court or the prosecution applying for limitation of this right is to terminate that right. That is also a falsehood, which of course I know the court will dismiss with the content it deserves. Courts have and continue to limit this right, and therefore that does not mean that the court has terminated a constitutional right. Nobody can be able to terminate a constitutional right, but the courts have powers to limit constitutional rights, except the right under Article 25. And this is not a matter of dignity. If it were so, Your Honor, then it will mean the indigent and poor people in custody do not deserve any dignity. finally, it has been said that the prosecution has not provided evidence that the accused person is a person of influence. I suspect that my learned friend was not serious about it, because every Tom, Dick and Harry knows the influence and stature of the accused before court.
Who is Tom, Dick and Harry?
The people out there outside this court. Now, Your Honor, I come back very briefly to highlight our response. Your Honor, I said, Your Honor, I've mentioned this, that what is compelling reasons to deny a person bond has been dealt with in a number of cases, and I'll only mention a few. Your Honor, I invited the court to look at our authority number 2, Milton Kabulit and others. That is 2011 EKLR. It's our authority number 2. Yes, you are. Yes, it's at the top. At the top of. We had already supplied a copy. If he wishes to enjoy himself, I can give him a copy which I have. This decision of the High Court is of course persuasive, and we will be urging the court to be persuaded by this decision. And at page 13 through page 16, the court isolated a number of reasons that will be deemed to be compelling reasons to deny a person bond. And may I point this, my lady, from the beginning, that the right to bail is not absolute. It is one of those rights which I said may be limited if there exists compelling reasons or circumstances. And the factors that may be considered include the nature of the right or fundamental right, 2, the importance and purpose of the limitation, the nature and extent of the limitation, the need to ensure that the enjoyment of the rights and the fundamental freedom by any individual does not prejudice the rights and the fundamental freedoms of others, and the relation between the limitation and its purpose. And at page 15, the court, drawing from the decision of the Supreme Court of Nigeria in the case of Al-Hajj Mahid versus Federal Republic of Nigeria, cited a number of reasons for declining to grant of bond as one, the nature of the offense. I will not emphasize the nature of this offense before this court. Number two, the strength of the evidence. The defense appeared to diminish this fact, that even if the evidence is overwhelming, so what? Yet, it is a fact that we consider. The gravity of the punishment. Of course, we do not wish to emphasize that this offense carries the death penalty if convicted. Then the likelihood of further charges being brought against the accused. And fundamentally also, the likelihood of the accused interfering with witnesses or may suppress any evidence that may incriminate him. That is our submission, that the accused here is charged with grave or offense or charge. He is a person of influence and is likely to interfere with witnesses. And in our affidavit, Your Honor, we have said that some of the witnesses are from the county government of Migori, where the accused person is governed. The other authority, however, which I will not seek to read, is the decision by your brother Judge Fred Ocheng, the case of Father Republic vs. Father Guyo Wako. That's our authority number 3. My lady, there was a mistake. We had attached a different, actually wrong ruling, but I've annexed. It's loose in the bundle, and I've also applied the same to the defense. The judge also looked at what may be compelling reason to deny the person born. And one of the reasons which my learned friend appeared to belittle is the gravity or severity of the sentence if convicted. And also that confessions had been made. We submit that these are critical considerations in denying the person bail. We also depend in our affidavit that there are threats and intimidation which may dissuade or scare away some of the witnesses. In our list of authorities number number 4 and number 8, we submit, Your Honor, that such are the considerations which the court must take into account when deciding whether to release a person on bond or not. And in the authority number 4, Your Honor, if I may revise briefly, the case of Diana Layman and another. This is a case where the accused persons had been tried for murder and they made application for release of bond. And the court considered the balance of the individual rights vis-a-vis the public interest. And at page 6, this is what the court said. The issue of public interest in national security and public safety as a matter of compelling reason in the consideration for bail is incontested. In fact, the court will be surprised that the defense is contesting this fact based both on the spirit of Article 24, limitations in the interest of others justifiable in open and democratic society. When national security and public safety are threatened, the very existence of the open and democratic and civilized society is also jeopardized. It must then become a matter of proper balance between the individual rights and the rights of the society, so that the individual is entitled to enjoy the greatest extent of his rights consistent with the rights and interests of others of public interest in a particular matter. Your Honor, it's now a matter of public notoriety. This heinous crime of murder is becoming current. The other day it was Sharon. Shortly thereafter, it was a baby, a kid in male. Hot on the heels of that was a case in Machakos. Even before the body could get cold in that one, is the case of Kilimani lady who was also murdered in cold blood. So these are things which the court must consider. That these issues are gaining currency. And the urge of suspects to try and cover their trails is very, very critical in this if the accused person will be released on bail. As I sit, Your Honor, it is important to understand the circumstances under which the deceased was murdered and the unborn baby also killed. She was lured into a trap of people closely associated with the accused person. That is our...
We want to object to that one. I think now counsel is testifying. It is not about that.
I want to suspect that my learned friend has not looked at the evidence. It's paragraph 19. Sorry, 7, 8. It's there in the evidence. Of course, I know the Sombera started from paragraph 10. And may have lost the other. We have deponed to that.
Where did you say lured? I want to say that word.
Your Honor, from paragraph 1, sorry, from paragraph 4 to 9, so 4 and 5, and then 7 and 8. Of course, that is our evidence, which we present before this court, but...
They don't know me.
Okay, let me just I will uphold that objection. It is not there.
That I would abandon that line. But in sum, my lady, what I am submitting is that we have demonstrated that there are compelling reasons for denying the accused person bond. And my learned friend, colleague, Mr. Mutesi, will now respond on the authorities.
You count how much time is left?
It's 16 minutes.
16 minutes, okay.
We have 16 minutes? Yes. I'll urge, of course, the court to find time to look at the authorities we have submitted. And the counsel for the watching brief for the family, they said if we run out of time, they will donate their 5, they remain with 5. Thank you.
But you have not run out as yet.
We are already married to donate.
My lady, allow me.
As you start, Mr. Muteti, can I see that pad I asked for? I want to see that pad so that we have some air flowing. Mr. Muteti, you have 16 minutes.
Begin with the preamble of our Constitution. My lady, the people of Kenya committed themselves to nurturing and protecting the well-being of the individual, the family, communities, and the nation. That is a loaded statement collectively stated by the people of Kenya. And in the arrangement of the Bill of Rights, again realizing the importance of human life, the first right is the right to life. Article 26. My lady, that emphasizes the need to protect human life by all means, by the state and all its actors, and the non-state actors as well. Article 26 sub Article 3 expressly states a person shall not be deprived of life intentionally except to the extent authorized by this Constitution or other written laws. 2 lives were lost here. We are not only talking about Sharon, but also an unborn baby who is protected under Article 26 sub Article 2, because life begins at conception. 2 murders. That, my lady, yes.
Don't say what is not there.
Thank you, my lady.
The information is important.
My lady, fortunately we saw that danger and annexed the 2 postmortem forms to demonstrate that fact. It's not a statement from the bar that we are making, but it's a fact that there were 2 lives and the postmortems are next to our affidavits.
The charge is one, and the issue of unborn child is not in that charge, so it's relevant.
My lady, our annex is evidence. And
Are you telling us you're going to amend to include
certainly we will go that direction at some point.
Let's deal with what is
Yes. And my lady, I was just going to touch on these 2 annexures to our affidavit. The postmortem. Just to demonstrate the gruesome nature. This murder was executed. It is the kind of a murder that will shock the conscience of men. by the injuries that he was knocked from these two hospital floors. That is stated to underscore the gravity of the offense as a consideration when this court addresses its mind to whether or not to grant bail. Lady, this accused offender has relied heavily on the decision of White Sagerai, that is the first decision in Mando. And I invite you to look at paragraph 20 of that decision and look at it together with paragraph 14, subparagraph 1 of our affidavit. Proof of interference with witnesses, that is what the decision states. Proof of interference with witnesses at paragraph 20 are not only valid, but include both direct and indirect interference. That is not us, it is the court speaking. And the decision goes further at paragraph 21, right at the middle. And my lady, the court states there is need of further proof that will demonstrate a real existence of likelihood that witnesses have or are likely to be interfered with. For instance, and I emphasize this part, for instance, the evidence that the two witnesses will remain in accused employment. That is important to us, my lady, when you look at paragraph 14, subparagraph 1 and 3. Some of our witnesses fall in the category that the court had in mind when making this decision. Further down, at paragraph 35, looking at other jurisdictions, the court cited the decision of Ahmad Muhammad, which is a local decision here. And I invite you to look at paragraph 35A and E. A addresses the question of safety of the public or any person. Our affidavit addresses the question of the safety of the family of the deceased, witnesses, and the persons resident in Migori County. Paragraph E, my lady, deals with exceptional circumstances where there is a likelihood that the release of the accused would disturb public order or undermine public peace and security. Again, that is not an idle statement. It is backed by our affidavit at paragraph 21 that the situation in Migori County is potentially explosive. That has not been discounted. My learned friends had a very good opportunity to ask that the deponent takes the stand, they cross-examine and rebut that statement. My lady, in the absence of any such rebuttal, this court should be pleased to treat that as the truth and nothing less. Again, the court in this same decision at paragraph 37, while granting bail, stated that it may be important that the prosecution, the last line, to prove that he is such a public figure that arresting him may lead to chaos anywhere in Kenya. Again, that goes to the previous point that I've dealt with. All these things were absent when my lady, you sat in judgment and delivered that ruling.
I urge you to find that that decision is distinguishable and cannot apply to the present circumstances. 5 minutes, yes, I'll finish. The second decision is Obado, that is the case of Julius Wanderi Mwangi. Again, this is distinguishable. At page 2 of that decision, the investigating officer who came before court simply assisted the defense. You will find that at page 2, paragraph 3, and the judge had no difficulty granting this. Over my lady to the case of Danson Mugunya. Again, undistinguishable authority. More than 10 witnesses in the last page, second last page of the decision. More than 10 witnesses have given evidence. And at paragraph 3, the judge says, as a result, all the ordinary wananchi witnesses, and he uses the word wananchi witnesses, have testified. So in his assessment, there was no threat or likelihood of interference, because all those who remained were officers. That is not the position in our case. And then finally, the question of witness protection that has been really amplified. In our humble submission, Witness Protection Act was not intended to uproot law-abiding citizens from their homes to witness protection safe houses. Merely because somebody wants to enjoy their right to liberty when they are accused of having taken a life. Lady, I urge you to find that is not the spirit, and it's not in all cases that people have to be removed from their homes. Finally, on the Ngetit decision, that is decision, I think the second last decision by my line friend, Mr. Cliff Ombeta. It may be well that one cannot say the state cannot secure with the public, but would the court then sit and close its eyes to obvious danger? Because the state also includes the court. The court has a duty to protect the citizens, to uphold the rule of law, and counterbalance private interest against public interest. I urge you to find this is a fit case where the accused person should be patient enough at this stage, and you decline to grant bail. Finally, bail can be revisited at any other stage. It need not be done at the seminal phase of a trial. With that, I urge you to dismiss the application and find no merit.
My lady, good afternoon, ma'am. On the side of family of the victims in this matter, my lady will be supporting the prosecution entirely with submission. We are amply urging this honorable court, my lady.
Just for the record, did this finding may have been done by any?
We didn't. We are urging this honorable court, when it will retire to men's ruling, to involve a balance of rights of an accused person and the rights, or the sacrosanct rights to life. My lady, we are before you on no lesser charge than majesty. My lady, the offense is grave. The prosecution have said that, sorry, the defense has said that the accused is ready to abide by all the court orders and is likely to attend the entire trial. However, the court should take into account that justice should not only be done, but it must be seen to be done. In relation to that, I'm trying to allude at a point that the court should take cognizance of other issues like the admissibility of an accused person in this matter, tempering or interfering with witnesses in this case. My lady, it is common knowledge that all the witnesses in this matter are subjects of the accused person.
My lady, I'm not so sure where we get that common knowledge from. I just want to remind my colleague that he doesn't have an affidavit. Let him just take the points of it. That knowledge is just his. We don't share it.
My lady, I have a few minutes.
Are there commit Obado supply? So you say you're the only one who shares that?
Very well, we stand guided. My lady, by denying the accused person's bail, does not infringe on the constitutional rights of the accused person. The right under Article 49(1)(h) is not absolute. The court has the power and the discretion to limit such a kind of right. And in so doing, we will be urging this court to deny the accused person in this matter right to bail. Very well. Now 5 minutes are up.
Yours are how many? 10?
My lady, perhaps not. I will be tired of it. I have had counsels, my colleagues from the prosecution and those watching it from the family. It is clear to me what is before court today is a thesis Lady, it is clear to me that what is before you today is a thesis of the grounds in which to grant bail or decline to grant bail.
the Constitution is clear that there must be compelling reasons for this court not to grant bail. Several authorities have been addressed on what compelling reason is. And I refer courts to the case of Republic versus Guyo, which cites the case of David Njuno Mbiu versus Koinange. The court describes compelling reason as forceful and powerful. Now, what Malani Court has gone through an authority with several reasons that this court must not grant bail. The first two is the nature of the offense and the punishment for the offense. Irrespective of the individual that has been arrested, the nature of the offense and the punishment is standard for all such murder cases. And our Constitution allows for bail irrespective of that nature and the sentence. We move to the strengths of the case. We do not have committal bundles issued in this court. There's no witness who was taken at the dock. There's absolutely nothing before this court on the strength of the case. We talked about likeliness of further charges. There's absolutely no demonstration in the affidavit in this relation. And even if further charges to be preferred, that is a case that the court will deal with on a basis case. Talked about confession. We have no co-accused in this particular case. We have no confession, my lady, before this court. So Dari did not resist the temptation of talking to the public gallery and talks about several other murder cases all over the world. I'm not so sure if that is true. I mean, all over the country.
Also addressing the gallery.
All over the country. My lady, every case must be dealt with in its own merit. There's no relationship between this case and all those that he cites. My lady, on the ground of influence by the accused person, it is not sufficient to demonstrate that he is a governor. And all the possibilities that a governor could do. If we were to go on speculation, surely the sky would be the limit.
What have they said that he has done so far or attempted to do? Zero. And as far as interfering with investigations or witnesses. The offense was committed on the 3rd of September. The accused before you was arrested on the 21st of September. He was a governor all that while, he still is. And the prosecution do not demonstrate a single thing he did or attempted to do in that relation. There's a general allegation that the family of the deceased has been threatened. The good deponent carefully does not say that this was done by the accused person before you. Or for that matter, say by who, when, and where. It's a paragraph completely not substantiated. The contrary, paragraph 10 of his affidavit, he demands that he's cooperated with the prosecutors, with the investigators in every way that they have sought. In paragraph 11, he also indicates...
My lady, I'm going to object to that line of response. If the defense realizes they forgot to say something when they were presenting their case, we have not analyzed it.
You answered what they have said.
Normally, that's fair. They have without interference of witnesses, without substantiating in paragraph 11. The accused person declares that he has not interfered with any witness and is not intending to. Malid, in that regard, Article 27(1) gives equal protection and benefit to them. We also invite you to invoke Article 159, Subarticle 2A, which grants justice to all persons irrespective of their status. In concluding that point, Article 160, Subarticle 1 invites this court to be subject only to the Constitution and the rule of law. Malady, on witness protection, may I just ask for 2 minutes? With bias on the floor. The issue of witness protection, we reiterate that there is a provision in the Act and the institution, and more important, there's no demonstration at all that there's any that has been threatened. Let alone by the accused before you. They also talked about threatening of co-accused. We have none before you. My lady, and as I conclude, the issue of public order and national security. In paragraph 21, the deposition is that there is potentially the situation will get explosive. Potentially. All these investigations have been happening in Homa Bay and Migori. There's been no riot. There's no report by the police or intelligence or any OB of any public insecurity or disorder. Lady, and I want to rely on the authority, your authority of Richard David Allen, on the proof.
I don't want to I'm not able to understand. Is this the time to submit the authorities when they should have done that, when they are making their
An authority is a point of law.
No, I said, if you've forgotten,
You touched on it, and the authority is a point of law, Mr. Dunn.
No.
Just allow it. Can you just continue?
Malezi, Mr. Oyoro urges this court that justice must not only be done, but be seen to be done, and that is this court to deny bail. He clearly has tried this case, convicted the accused, and truly believes that denial of bail is the punishment.
Mr. Sakari, you like to tread where you are rattling.
I appreciate the indulgence. We humbly apply for the
So, I mean, you know the thing that he has convicted and
let me just conclude by demanding that there is a presumption of innocence. This case is yet to be tried.
It's not a presumption, it's actually a right.
In fact, denial of this right without a compelling reason is what will be infringing the accused constitutional right. Most of it.
you have been having academic.
Most of
I think yesterday you mentioned about the matter coming back before the court tomorrow.
No, the matter, I think we are done with this. What we have tomorrow is a different matter, which the court has given some time for the accused to be brought back tomorrow.
So this one is not coming back tomorrow.
No, this one, we have not so far consolidated the cases, so we'll be awaiting the ruling of the court. The case coming up tomorrow is for somebody else, and of course related.
Your lady, Mr. Ondari seems to have selective memory. Yesterday he said on Wednesday then we are going to consolidate this case with the other one. So
And that's why I'm asking.
Yes.
Because I like to talk about
Yesterday we
consent.
said, may we argue this application tomorrow, on Wednesday, when we hope to bring the other accused person. The court ruled that no, this is a separate case, let's deal with this case. Each case will be dealt with.
Can I read for you what he said?
Yes.
We have another matter coming up on Wednesday related to this one.
Yes.
So you are saying the earliest you can argue the application was Wednesday. In the meantime, you ask the okay, that has nothing to do. But you are talking about consolidating.
Yes.
So you have no intention of consolidating tomorrow.
We shall when we take plea. We are applying for consolidated, but what is before you, Honor, is a bail application, and
there is a reason why I'm asking that.
We will be bringing some other people tomorrow related to this case. And
but this one is not coming tomorrow. That's all I want to find out. It's not coming up tomorrow. This one.
No, there is no.
Okay.
All of that effect. Unless, of course, the court wishes or they request that they want to come to.
The issue was consolidation. So if there is no consolidation, it's okay. Getonga. Where's the dad?
What perhaps maybe what I perhaps conceive the court to be saying is that we are going to argue another application tomorrow.
No, I'm asking about consolidation of this with another, because that was the indication you gave.
We shall be at the opportune time when we all be.
But now not tomorrow.
Not tomorrow. Okay.
Can you come on the 27th for the ruling? That is this Thursday.
Most of like what time? What time?
It will be 2 o'clock.
Most of like. I really wish to notify the court that we have an alibi which we will be filing on 27th.
Okay, you can file any time, there's no problem. But there's something we are calling retire conference, and that's when you can bring all those things. Yes. And I think on Thursday we should settle on a date for that. But if it's going to be consolidated, then we have to wait until the matters are consolidated. And then you can do a pre-trial for all of them. Yeah. So 27th in the afternoon, where is the accused person? I cannot see him. 27th at 2 o'clock you come for your ruling. Is there anything else? Court is adjourned.
This is NTV.
All bets on sports.
What is fair?
Huge winnings.
What is fair?
High odds.
What is fair?
Fast pay.
What is fair? What is fair?
Bookmaker Company.
First time ever from Downey. I don't like my son to smell bad when he's playing. That's why I switched to Downy Concentrate. With only 1/3 of a cap, its new formula boosts freshness, releasing perfume bubbles that burst with every move, giving me better freshness than a detergent on its own, so that my son and I are always ready for celebration.
There's no laundry without Downy.
What are you doing here?
I thought you'd be happy to see me.
Bad luck to see the bride on the morning before the wedding. After all these years, Donovan is finally proposing.
My name is Sasha. I'm here to speak to that woman who is getting married to Lionel. I'm his ex, and you have a child together.
I'm gonna look so hot at the altar. Your dress? Just right over there. I thought this was a curtain! There's no way I'm wearing this. Why are you wearing a wedding dress? You wanted me to be covered from head to toe, no? Huh? Look, even the veil covers my face.
You're afraid of violence. We get down if the play calls for it, bud. We're here for business. That's right.
We can close each other's eyes right now real fast.
And ain't nobody gonna make no money.
Things get emotional, moves get messy, and the wrong people die.
There's undercover and then there's switch. Where was up? You think I'm in so deep I forgot? I never doubt you.
Kuishi life ya mwanaume kamili ni lazima ujue status yako ya HIV. Keep zile vitu na like zikiwa sawa. Kuwa mwanaume kamili. Jua hali yako ya HIV leo. Sasa unaweza kujipima HIV kwenye usiri wa nyumba yako.
Phase 1 of the development, consisting of 160 units, is almost complete and ready for occupation in March 2019. Prices start from 6.9 million. The show houses are ready and open for viewing daily.
Kennedy Odede. Kennedy is now, I think, about 34 years old. And Kennedy started as a street child with little education, growing up in Kibera, started with Trintibob. He bought a football, started a community, and now Shofco is reaching, I think, about 220,000 people in Kibera, and now stretching out into places like Bangladesh. He is addressing a number of SDGs. So he has Kibera School for Girls because he understands how important it is to set the right foundation for girls. He has a gender violence defense unit. He has a clinic which, whenever I go into Kibera and I see the clinic, I'm shocked at the quality of care that he's currently reaching. And then he does a lot of other stuff, providing clean water. So as a good local example, Kennedy Odede, I think, provides a very good model for what the youth can do for achieving the SDGs. He's recently written a book called Find Me Unafraid, and that's now being made into a movie. My real big disappointment in all of this is that he finished the book before he met me, because I wanted to be included in the movie so that Denzel Washington can play me. Join us on 27th of September, live on NTV.
Setting the agenda.
We've got a lot to talk about.
Talking challenges.
Is that something you guys would do though?
Absolutely not. And triumphs.
I think it's good. It's a private thing.
I don't know what you guys think about equality.
A space for Africa's women to be heard.
An African woman should be seen, tenacious, resilient, a force to be reckoned with. An African woman should be heard.
Join the conversation.
Their responses were very interesting.
The She Word from the BBC.
Did you know that Downy Concentrate softens and freshens 2.5 more clothes per litre than the leading fabric softener? It's more concentrated, so use only 1/3 of a cap.
Living in a top house.
Wagwan. Flix is in
here? Alikuwa na early morning classes.
Dude, I'm not here to see Flax. I know Flax is in class. I'm here to see you.
Amekuja kunichukua tuende date atafuko na tumfukuze.
Who are you? Flex!
What on earth is going on here? Alex!
Living in a top house.
Kuishi life ya mwanaume kamili ni lazima ujue status yako ya HIV. Keep zile vitu na like zikiwa sawa. Kuwa mwanaume kamili. Jua hali yako ya HIV leo. Sasa unaweza kujipima HIV kwenye usiri wa nyumba yako.
The people of Kenya will again look up to their MPs.
The 8% on petroleum products is not effectively 8%.
Will as many as our contrary opinion say nay? The ayes have it. The majority leader came and started pushing people to go out.
The leader of majority employs a number of tricks to make sure that the government agenda is complied with.
Side shows kwa bunge ndio tueleze sisi raia kuna kitu inaendelea na kumbe walikuwa shamalizana. There is no Kenyan who is saying they don't want to pay taxes.
Mimi kama mkaaji wa Kisumu nimeipinga kabisa.
Maskini imezidi.
Raila ameuza Kenya.
Mtu mwenye ametuharibia mheshimiwa Raila Amolo Odinga.
This is where the real conversation happens. NTV, turning on your world. The following program has been rated GE. It is therefore suitable for general family viewing.
Nimeshika vita, uwacha nikupe saluti baba. Nimepigania vita, uwacha nikupe saluti baba. Wakipigana na wewe, watajua hawajui. Wakibishana na wewe,